Next case will be Lane versus State. And let me thank both of you all for agreeing to move your oral argument, because I know there is a conflict here, so. All right, sir, you may proceed.
I would reserve 5 minutes for rebuttal.
Okay.
May it please the court, my name is Kevin Monahan. I am counsel for the appellant Julie Lane in this case. The facts in this case are somewhat unusual for a criminal case in that they're really not in dispute. On the night of May 4th, 2011, a search warrant was served on a single-wide mobile home in a remote area of Interlochen, Florida. The basis for the search warrant had been that the occupant of the trailer, a woman by the name of Melissa McFarland, had sold 2 prescription pills of hers, 2 oxycodone tablets, to a confidential informant. Precisely what the search warrant was for is unclear, because these were actually lawfully held prescriptions, and so they would not have actually been evidence of a crime. But to serve the search warrant, the Putnam County Sheriff's Office assembled a 15-man SWAT and rifle support team and went to the home of Melissa McFarland at around 10:30 at night. The team was led by Lieutenant Scott Surrency. At approximately 10:30, they made 3 loud bangs on the door, accompanied by yelling out Sheriff's Office search warrant. They then immediately detonated.
They banged on the door?
Yes.
I thought they banged on the, reading the record, it sounded like they banged on the side.
Okay, they were at the door, right? I think
They didn't bang on the door, right?
The
Isn't
wall.
Wasn't that kind of an interesting, a significant point? They banged on the corner of the home instead of the door?
I kind of overlooked it. I didn't really put much into it. And,
Okay.
I didn't think it would have made too much difference where they banged. But immediately, they detonated 2 flashbang devices right outside, and then breached the door with a battering ram, at which time the officers swarmed into the living room. The 2 occupants, Melissa McFarland and a roommate who happened to be there, grabbed nearby handguns and fired at the intruders or the deputies, during which case 1 deputy, Dennis Hayes, and the appellant were both shot.
So what is your, then clarify for me your argument. Why was the knock and announce deficient here?
First of all, 93309, for whatever reason, it should be the announce and a knock and wait for a reply rule, but is simply recalled the knock and announce rule. The knock and announce wasn't the problem. 93309 states that before you may breach or break into the home afterwards, you have to afford the occupants of the home a reasonable period of time to deny you admittance. I think it's clear from very beginning to end in this trial there never was ever any intention.
All right. Now, there are exceptions to that rule, correct?
There are exceptions, Your Honor. There are 4 exceptions.
Right, and one of them is peril, and there was testimony that the police had evidence that these individuals had firearms and would pull them out when people came to the residence. So at least you had evidence of that.
That was the only evidence.
All right, but now,
But I would.
but let me finish. Trial counsel requested the judge to instruct the jury on the knock and announce statute, didn't he?
No, I think he requested something on excessive use of force or something.
Well, he also asked the asked the judge to define what applicable law was.
But never, the term knock and announce in 93309 is never mentioned anywhere in the trial. And there was no jury instruction.
What did you just say? I'm sorry, I just missed that. You said 93309 was never mentioned in the trial?
No, never.
What about the trial transcript, page 1051, 1052, 1053, and 1054?
If I must have missed those, Your Honor, if they do mention 93309.
1050, at 1051, trial counsel is challenging the knock and announce, and in response to the judge asking what he was challenging, the trial counsel said that he was challenging the location and duration of the knock, that it didn't comply with 93309.
Okay.
And they have a discussion over a couple pages anyway about that very issue.
I mean, and clearly the trial attorney was aware of this statute. I mean, this is not like, never heard of it before, and, I mean, this was a topic of discussion. You just seem to think he didn't do a very good job of how the topic was conveyed to the trial judge vis-a-vis how the trial should have progressed.
For the most part, the trial counsel, if there were brief mentions of it, perhaps, again, but for the most part, it should have been the central issue of the trial. What happened that night should have been properly argued to the court.
He got out evidence that they didn't wait for a response, correct? I mean, that evidence came out pretty clear that they didn't wait for a response, right?
But he never confronted the...
Wait. Well, sometimes you want to you want to make that known to the jury through jury instructions and closing argument rather than through the testimony. I mean, he had evidence. He got out the evidence that they didn't wait for a response. That was pretty clear. They all agreed they didn't wait for a response. They were going in. He got out evidence of the short time frame. He got out evidence that they didn't knock at the door. So he had that evidence. And then he asked the judge, he argued the Spradley case, which you suggest in your brief that he wasn't even aware of, but he argued the Spradley case as to why the law enforcement did not comply with the statute. He argued to the trial court that they gave insufficient time for the occupants to respond, that they failed to knock at the front door like they were supposed to, and that they did not order the occupants to open the door. They just said sheriff's order, search warrant. He asked the court to determine the applicable law regarding exception D to the jury instruction, which was denied, and if he had granted that, he would have been set up for a great closing argument.
Well, first of all, when you sit there and say he brought it out, if you look, it was during cross-examination that he brought out the fact that they never waited or never intended to wait. He asked Lieutenant Surensee, and it is during cross-examination that Surensee basically said, we never had any intention to give them an opportunity to answer. He said, we would have dealt with that if we did.
And that's good. That's good for the defense
Well,
side,
it's
right?
good for me on appeal. It's bad for me when Lieutenant Surensee says that, and then the defense counsel acquiesces to what Lieutenant Surensee says as being essentially accepting it as the proper way to search.
But if he had won the jury instruction argument, he could have argued to the jury that the judge will tell you that what they did was improper. Right?
But if he
had won his jury instruction arguments, he could have made that argument that the judge will instruct you that what they did was wrong, that the statute says they're to do this, this, and this, and you heard from all the officers they didn't do this, this, and this. And so the judge is going to instruct you that the law officers did not follow the law. I mean, that's a nice setup for a closing argument. Now, he lost those jury instructions arguments, but he made them.
But at the same time, throughout the trial, he never challenged. For example, when these officers, and there was a slew of them, as they came forward, and when Lieutenant Surensee made it clear that there never was ever any intention to allow them to answer the door, that was never part of the plan, they would deal with it. He totally acquiesced in that. He never challenged it. He never
Counsel,
confronted.
why would he challenge that? He got the answer. He got the answer he wanted. He got the answer. He got the perfect answer that he was going to use in closing.
But he got an answer that essentially told that jury, this is the way it's supposed to be done. And even in his closing arguments.
And then he asked, in the charge conference, he asked the court, he challenged that and referenced and brought up 93309 and discussed it for at least 4 pages in the charge conference, and the trial court overruled that.
But at the same time, when in his closing argument, he goes along with everything the state says. At every point, he praises Lieutenant Sorensen in his closing argument for his professionalism, and he said, this is, he knows what he's doing, this is how it's supposed to be done. It's not how it's supposed to be done. The central issue of this trial was that the two occupants in that house had their home invaded, they had bombs set off, and one of them, an innocent bystander, was shot, and the whole thing is laid.
Wasn't the central issue whether your client knew they were police officers or not?
The central issue should have been whether or not my client was given an opportunity to properly formulate.
Well, let me ask you this. If the jury was to find that the police did not comply with the knock and announce statute, and further concluded that your client knew they were police officers and still shot at them, what should the verdict be?
First of all, I have to go back to the first part.
Oh, no, I mean, I'm getting to the real issue in the case. Let's assume that the jury concluded that the police did not comply with the statute, but concluded that she knew they were police officers before she started shooting. Is the proper verdict guilty?
No. How could they?
Why
How
not?
could they conclude?
Why not?
How could they
Why
conclude
not?
it? First of all, the central issue of this trial should have been the intent, whether or not.
That's what that's the knowledge.
Yes, and that's what I'm trying to say. This case deals with, look, Julie Lane right now is serving life in prison. She is serving life in prison because at 10:30 one night while she was listening to some music on her computer.
You're avoiding my question.
All of a sudden.
Sir, I want you to focus on my question.
We're not a jury. Theatrics doesn't help you.
So I want you to focus on the question. If the jury concluded that the police did not comply with the knock and announce statute, but also concluded that your client knew they were law enforcement officers and shot at them nonetheless, would that support a guilty verdict?
If they concluded, well, first of all, if
That's a yes or no?
first part of your question
Yes or
was
no?
if they concluded that they did not comply with the knock and announce rule.
Correct, and they concluded nonetheless that she knew they were law enforcement officers but shot at them anyway,
First
would
part
that
of it-
support a guilty verdict?
If I could get to the first part of your question.
Just,
Because-
my
It's all
question
one
calls for
question,
yes
counsel.
or no.
It's all one question.
Well, the question assumes that the jury concluded that they did not comply with the knock and announce
Yes, it
rule.
does. And what's the
Right.
answer?
And the answer is, how could they conclude that? There's nothing in the trial.
I
that
said
would
did
give
not
that.
comply. My question was, assume the jury found that the police did not comply with the statute, but nonetheless concluded that she knew they were police officers when she started shooting, would that support a guilty verdict?
First of all, I suppose yes, the way you worded it, yes.
Okay, so
No,
wouldn't that suggest that the central issue is whether they believe she knew they were police officers when she shot?
No, because the central issue, you assumed that the jury concluded that the knock and announce rule was not applied with.
No,
The duty of
no.
any attorney is to confront the witnesses.
Let's try a different route here, apparently. Forget the knock and announce rule for a second. 10 police officers from Putnam County Sheriff's Office walk up to your lady's front door and just open the door and walk in. Say, police, we're here. Could she then turn and get a gun and shoot him, say, get out of my house, boom, 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 boom?
Of course not.
Okay, so, but clearly under my scenario, that's probably an improper entry into the house, right?
I'm sorry, what?
That's probably an improper entry for the police to just barge into somebody's house.
That's correct.
Forget about knock and announce, because we're kind of, I think, you're not appreciating what Judge Evander and Judge Eisnagel are asking you. So if it's an improper entry, and your lady's at the kitchen table, she sees the officers walk in, she reaches down and pulls the gun and starts shooting because in her mind, that's an improper entry. You agree she can't do that?
You keep talking as if this
All right,
woman
that's
who had
it.
a few sparse 2 or 3 seconds, everything that happened that night was not decision-making, it was reaction.
But, and that's kind of where I'm going. I think the focus in this case, my guess is that what the jury focused on was, did she know they were police or not? And if they knew that they were police and they were going to find her guilty, and if she didn't know they were police, then they probably would have found her not guilty.
I think what they looked upon is the fact that from beginning to end, this case was portrayed as a heroic textbook application of law enforcement tactics, when in fact it was just the opposite.
Do you believe that trial counsel should have done something pre-trial, or you're just focused on deficient performance at trial?
Deficient performance at trial. I think, the primary purpose of trial counsel is to confront the witnesses against.
Was trial counsel's effort at the charge conference, at pages in the transcript 1051 through 1054, where trial counsel argues that the knock and announce was deficient as to the location of the knock and the duration, was that enough, those 4 pages of argument, was that enough to raise it on direct appeal, to raise the issue on direct appeal?
I don't believe so. I don't.
Why not? Why was that not enough?
Because I wasn't, to be honest with you, I couldn't answer that question, Judge.
Okay.
May it please the court, I'm Rebecca Wall, Assistant Attorney General representing the state in this appeal. The record shows throughout the record that the sole theory of defense, the strategy that was picked, was lack of intent, specific intent for her to attempt to murder law enforcement officers. And the basis for that throughout the entire trial was that they didn't execute the search warrant properly. And because of that, she had no idea they were police officers. So the sole issue that was raised in the motion for post-conviction relief, that is, that counsel failed to present this strategy, is refuted by the record throughout. That's exactly the strategy that counsel did present. Therefore, because the record refutes that claim, that is, the record showed that was the strategy, the trial counsel properly denied the motion for post-conviction relief, and therefore, this court should affirm.
Any questions? None. All right, thank you. Any rebuttal?
Simply, I would just, I feel like I look at this case of Richardson versus State, and this quote from there, I think just absolutely, in failing to permit time for a response and executing a search warrant, the police follow a recipe for tragedy. We wish to see neither our law enforcement officers nor our citizens harmed. In this day and age in our country, many citizens lawfully possess firearms and are aware of the frequency of home invasion robberies. Awakening citizens from slumber and depriving them of an opportunity to recognize law enforcement's presence and purpose could result in a misunderstanding with horrific consequences. That, aside from the fact that she was listening on her headphones instead of in a slumber, describes exactly what happened that day. This isn't my language, Your Honor. This is the language of the courts. This is not the way it's supposed. This is what happened there that night is exactly as what was described by the court in that. The failure to give these individuals a proper period of time to engage in the decision-making process that we have now taken this person's whole life away from her because of something she did in the space of a few paltry seconds.
But the counsel argued that to the judge and asked for instruction, and that would have provided the jury with an avenue for relief. The judge overruled the objection. It was preserved for direct appeal, not raised on direct appeal. And now you're saying that the trial attorney was deficient, apparently because he didn't sufficiently convince the trial judge to go along with his defense that the officers acted improperly. Isn't that?
That wasn't the defense. He went along with how they acted. He never challenged what they did that night.
He sure did at page 1051 through 1054.
Okay, I understand that. But for example, the one point that I cite in there where he asked Lieutenant Surrency, what is the purpose of the knock and announce? And Lieutenant Surrency simply says, it's a knock and announce to alert them of our presence. At no time does he say, by the way, you're supposed to allow them a period of time before you breach. So he...
That's not even a question. Is it your position trial counsel was supposed to inform the officers of their obligations?
You should have confronted him with the actual language of 93309 and not any...
But that's a legal conclusion, because then you'd have to get into whether one of the exceptions applied or not, and that's not something you ask a witness. Well, say, well, do one of these four exceptions apply? I mean, that's for the judge to instruct the jury on what the law is.
But if you spend your entire time in the trial acquiescing to it and there was nothing in the jury instructions that precluded counsel from, we don't even get to the jury instructions. He should have been confronting the witnesses with the requirements and should have asked, if they wanted to raise the office and explain officer peril, they could have. But again, courts have already held mere possession of firearms won't do it.
Is that even a proper question to ask the officer what the law is on that subject?
I think it's absolutely essential if the officer's up there testifying as to what we do when we serve a search warrant.
Once an officer essentially answers the question the way you want him to answer it and essentially concedes that he or she did not comply with the statute, isn't asking anything else, asking one question too many?
I'm sorry, I have to go back because I don't see, I go back to the.
The officer conceded that they didn't have any plan to wait for a response, correct?
Actually, no.
What you just said.
He did say that, but he never conceded that that was improper. He conceded
Once you get that answer, isn't asking another question one question too many?
No, because you should have gone on to answer, are you not, after you knock and announce, are you not obligated to give the occupants an opportunity to
It
answer?
depends on whether one of the exceptions applied. If one of the exceptions applied, then it was proper. If one of the exceptions did not apply, then it was improper. As the judge's function to instruct the jury on what the law is, not for the attorney and the witnesses to instruct the jury on the law through their questions and answers.
But that's why I'm saying is the officer peril exception clearly didn't imply, as the Richardson case points out, that when we deal with the.
If that's the case, then was the error in the judge's instruction, in the judge's failure to give proper instructions to the jury?
The error was in a failure of trial counsel from beginning of this trial to the end, to failure to confront the witnesses over the failure to allow his client.
But if the judge had instructed the jury that there were no exceptions that applied and that the police did not comply with the statute, as the defense requested, that would have helped close an argument. If the judge failed to do that, as requested, is that an issue for appeal?
Again, I have to get back to that part of the record, Your Honor, and
Okay.
I'm sorry. It's
All right,
I'm not-
thank you. Court will be in recess.